Our fifth problem scenario concerns measures equivalent to quantitative restrictions. These are, you will remember, rules, regulatory barriers or other measures imposed by states that make it more difficult for goods from one member state to be sold in another. So what we've got here is another email, and this email sets out two different issues. One is a Belgian measure, the other is a Dutch measure. Consider them both separately. It's the same steps that you use for both of these situations. So first, I've already told you we're talking about measures equivalent to quantitative restrictions. So what's our treaty article for measures equivalent to quantitative restrictions? Does the issue fall within the scope of our relevant treaty article? For this, you need to consider our test for a measure equivalent to a quantitative restriction. If it falls within the definition of a measure equivalent to a quantitative restriction, then there are steps that need to be taken thereafter. If it doesn't fall within the definition of a measure equivalent to a quantitative restriction, there's nothing that can be done. So first of all, consider that question. Does it fall within the scope of a measure equivalent to a quantitative restriction, or does it fall out with this rule? Then you need to determine what type of measure you're dealing with. Is it a distinctly or an indistinctly applicable measure? Because remember, if it's a distinctly applicable measure, it can potentially be defended under Article 36 of the TFEU. If it's an indistinctly applicable measure, it can either be defended under the treaty or else under our rule of reason. Is it a mandatory requirement in the public interest? Does it serve a legitimate social purpose? So our next step is to look at either Article 36 or else look at the various case law and justifications, etc., for mandatory requirements in the public interest. If you are relying on Article 36, remember you cannot rely on Article 36 if a measure is nonetheless arbitrary restriction or disguised discrimination or disguised restriction on trade. You also have to determine in either case whether or not the measure is proportionate. So look at our test for proportionality. Remember, proportionality is just going beyond what is necessary to achieve the legitimate social objective that the state is seeking to achieve. So follow each of those steps one by one. Does it fall within the scope of the rule? Is it distinctly or indistinctly applicable? Can it be defended either as under Article 36 or as a mandatory requirement in the public interest? Is it nevertheless some form of disguised discrimination? Is the measure proportionate? Follow those steps for each one. Make sure that you cite your case law and your legal authority throughout. Make sure that you apply the law to the facts and summarize briefly, and there you have it. That's your answer.